The moment of an arrest is about to occur. What should you do? Hi, my name is Bob Bianchi from the Bianchi Law Group. Our team of former prosecutors is very proud in our criminal defense practice to be national TV legal analysts and all the media and radio shows and stuff that we do, to be able to answer some of the most basic questions that in the criminal defense practice that myself and Dave Bruno manage. We see these questions coming time and time again, and there's really no instructional videos that are out there. But we have actual real life experience where people are calling us day and night with regard to issues that they have and asking us to help them. This comes up that whether or not we as the attorneys knew that an arrest was imminent, we literally get calls sometimes from individuals who the police are knocking at their door and we're involved in a dynamic situation in which they're saying, I'm going to be placed under arrest. What should I do? So let's slow down. That's the most important thing. This is an intellectual process, despite how frightening it can be and how emotional you may be during one of these circumstances. What you do at this critical stage of the criminal justice process can make the difference between liberty and not. So it's important to remain as calm as you can. I'm a martial arts guy. I love fighting. And I realize that even myself, when you're in a fight, sometimes you can tense up and you can forget and not allow that muscle memory to take place. So it's important for you to be calm and cool, collected in a situation in which you're fighting literally for your life. So the first piece is, if the police have an arrest warrant, is to let them make the arrest. It is a frustrating question because there's a million things to talk to a client about when they're saying, should I let the police arrest me? The answer to that question is yes, you should let the police arrest you. If they have a judicially authorized arrest warrant or a complaint, you can argue down the road whether you should have been arrested or whether you should have been charged or whether you're guilty or not guilty, but it's not to do it right there. When you create an environment that's dangerous to the police, it not only hurts you with regard to your case when the prosecutor reviews your file down the road and they ask the police, what do you think about this person? This is what really goes on behind the scenes. Prosecutors are evaluating a lot of things. And if they have a police officer that has a particular dislike for a client, it's not going to be to your benefit. And the second thing is, it's dangerous. Police have a job to do. They don't know you in all likelihood. So you don't want to create an environment. That's just a matter of common sense. So you're not fighting your case on the street. You do it in the court. You submit and be respectful to the police officers, despite how angry you may be about it. But here are the two golden rules I say all the time. At that point, you're going to probably be in handcuffs in all likelihood. It can be humiliating, maybe in front of your family. It could be in front of your neighbors, your business people, whatever. And they're going to take you to the police station or the prosecutor's office, and they're going to go through processing. Now, we get this question all the time. What about my Miranda rights? I haven't been read my Miranda rights. Well, it's, sometimes knowledge can be dangerous if you don't know the whole thing. First of all, to put it in a nutshell, laws are very complex, and this is just a nutshell. Miranda has to be given during a custodial interrogation. That means that you were actually under arrest, that your liberty was deprived, that you weren't allowed to move or you weren't free. And secondly, that you're asked questions. Okay, you're asked questions about the offense. Custodial interrogation. It's not a get out of jail free card and they didn't read my Miranda rights. If in fact your Miranda rights are violated, that is, a court later determines that you were in custody and you were asked a question and you weren't properly given your Miranda rights, that would be done later in the court process through a motion to suppress the evidence and throw the evidence out for the violation of your Miranda rights. So there's a little bit of a misnomer. And if you're calling your lawyer or whoever may be your legal counsel down the road and start talking about, I wasn't read my Miranda the minute they arrested me, the cops don't have to do that unless they ask you a question. Although most police officers reflexively are going to read your Miranda rights because they just know that that's good practice. You can expect to then be brought into a police car. I think this is kind of obvious, and you'll be in the back seat and you're going to be taken to the police station. And at that point in time, you're going to be processed. Now, this is where a danger period exists for a client. Trust me, telling you with the experience as a prosecutor and as now a criminal defense attorney. Our team of former prosecutors at the Bianchi Law Group see all the time. They assert their right to remain silent when they're arrested, but then they get into that cold, dark, or well-lit probably room, actually. And You're by yourself, you're scared, you're in the inner sanctum, there's police officers, there's guns, there's badges, and there's this tendency all of a sudden to think that, hey, well, if you just talk to us or whatever, everything's gonna be okay. Trust me, nothing you say is going to be beneficial to you. If you have something that you need to say in order to defend yourself down the road with a attorney at your side, those messages can be communicated. There is not the time to do it, because it's what they call reinitiation. If somebody has searched their Miranda rights and then voluntarily says, hey, you know what? I changed my mind and now I want to speak to you, the police have an absolute right to be able to take that statement. Stay strong when you're in that environment. Whether you're guilty, whether you're innocent, doesn't make a difference. Let a lawyer down the road make that decision. So I'm going down a checklist of things. I actually wrote people that are asking, like, what happens during the process. Yes, you will be fingerprinted and photographed. And we're also asked, you have a right to legal representation. Okay, so not literally at the time, of course, you're entitled to legal court representation at any time, but literally while they're processing you, your lawyer is not going to be in there. They're going to have the ability to be able to do what is necessary. And that's why it's that vulnerable period. The lawyer, when we're involved, we immediately fax, telephone, email. We are the attorneys, and we are asserting the right to remain silent and the right to have counsel present before any question. That's something we do at the Bianchi Law Group as a routine the minute that we are in one of those situations, because that critical gap, we understand as former prosecutors, is a space, is a place where people make big mistakes. So the lawyer can't wait on that in order to invoke the client's rights. Once we know a client is arrested, once we know where they are or where they're going or what department arrested them, we're sending notifications both to prosecutors and police saying not to interview that individual. People have asked about the difference between a warrant and a summons complaint. I talked about this in another video. I'll just do it quickly. The warrant complaint, the charges can be the same. You're charged on a complaint, okay? It's a document. And that document is the state of New Jersey, and it'll have a defendant's name underneath it, your name, your friend's name, whoever is the defendant in the case. And in that, there's going to be a probable cause statement. It's going to basically say what it is that you did. And there's going to be some statutes that are going to say what criminal laws were violated. And then there's going to be a signing by a judicial officer as to whether or not probable cause has been established and whether or not an arrest warrant, a warrant complaint, will be issued. And on a warrant complaint, it simply means what it means. That means that they can take that warrant, they can arrest you. And once you go to police headquarters and they fingerprint photograph you and all that, on the warrant complaint, you're going to be continued to be detained until you get before a judge. You're going to continue to be detained until you get before a judge. On a summons complaint, however, the same information exists on that complaint, but it's written on, it's just the difference between what they write is an S or a W on the complaint. And that means law enforcement is giving you that complaint, and there's a court date on there, and they expect you're going to be responding to the court date and that you'll be there. So they let you go at that point in time. So the warrant complaint is obviously more serious, and warrant complaints are typically for more serious crimes, or if law enforcement believes that you pose a significant risk. While you're being fingerprinted and photographed, typically speaking, police and prosecutors are communicating with one another as to whether it'll be a summons or a warrant complaint. People are asking the next stage in the proceeding. Well, there's a detention hearing that will come up next, whether if you're detained. And then even after the detention hearing, whether it's on a warrant complaint or a summons complaint, there will eventually be an arraignment. And that is a process where everybody gets very nervous when they hear the word arraignment. I'm going to go through these quickly. We'll have bigger videos on each one of these subjects down the road. But an arraignment is a very informal process. It happens very early on in a case where simply, really, to be honest with you, the court's kind of getting its arms around the case. The court's bringing you in, prosecutors there, hopefully your defense lawyer there, capable defense lawyers there, you're there, the judge is like, okay. And they're going to make sure that the defendant is aware of the charges that are filed against them. And they're going to ask the defendant and the defense attorney for a plea of guilty or not guilty. To be honest with you, it is such a pro forma quick process. Typically speaking, most judges are going to enter a not guilty plea on your behalf. There's virtually nothing you're going to have to say in an arraignment other than really verification of who you are, where you live, your date of birth, things like basic biographical information. And if you are not detained, you'll be allowed to go. It's an in and out procedure. So you hear a lot of these things, people get nervous. They hear these words, they see them, hear them on TV. They really don't know them. But in the real world, arraignment is a very informal process. It just makes sure that everybody knows what's going on and sets another court date In between that date, prosecutors and defense attorneys will exchange police reports and things we call discovery. That's information about the case so that they can begin the process, the defense attorney of representation and the prosecutor putting their case together. And while all that's going on, typically prosecutors and defense attorneys will be negotiating the case, discussing the case, talking about whether or not there's enough proof in the case or not, and many other things that are going to be happening. There's more that we're going to do in a separate video about detention hearings, the role of a defense lawyer, potential outcomes, long-term consequences. Okay, but for right now, suffice it to say, at the beginning of the arrest, you're going to be uncomfortable. Submit to the arrest. Your place to argue is in a courtroom. It's not on the street. Remain silent under all circumstances, whether you're guilty or whether you're innocent. Don't be fooled or cajoled into giving a statement. I can't tell you how many times as a prosecutor we were able to prove a case only because a person tied up a piece of information that they didn't even know was relevant, but ultimately sunk them as far as their case is concerned. And moreover, even a completely innocent person, you can worry about whether what you say can be misinterpreted, misunderstood. And I have seen that in a career. You can be assured. You're going to be fingerprinted, photographed. You're going to be booked, as they say. It's uncomfortable. There'll be a decision as to whether you're going to be released on a summons complaint or a warrant complaint. But the two golden rules are remain silent, hire the best lawyer that you can afford. Lawyering makes a difference. I hope this was informative to you. We love answering these questions again, and we get a lot of it from the media side where people ask us this, but this is practical day in and day out questions that I get every day with the clients that retain us at the Bianchi Law Group. So we often point our clients to these videos and actually send them to our videos because to us, a better informed client and understanding the process, understanding the language, understanding what's important and what's not important eases their mind in an otherwise very tense situation. And that ultimately leads to better representation and a better result. Thanks for listening. I hope this was informative. Of course, look at any of our other videos and any of the links that we have down below. Have a great day.